The vast majority of clients are satisfied with the service that they receive from their solicitor. Occasionally, this is not the case, and solicitors need to know how to deal with the situation when it arises. The causes of complaints often mirror the causes of professional negligence claims. Host Julian Morrow chats with New South Wales Legal Services Commissioner John McKenzie about solicitor complaints. They look at the key causes involved, how a client relationship can get to this point, how solicitors can form an appropriate response and thereby reduce the likelihood of complaints.
John McKenzie, thanks very much for speaking with us.
It's a pleasure, Julian. I'm looking forward to it.
John, you're the Legal Services Commissioner of New South Wales, which means you get over, 2,500 complaints a year. What are the most common complaints that your office receives against solicitors?
Two ways to give people some information on that. First of all, the areas of law that generate the most number of complaints to my office. Number one is well and truly at the top of the list is family law and de facto relationship law and everything to do with that. Probably won't come as too much of a surprise to people when you think about the emotions involved. The second area of law that is second to that is wills, probate and family provision cases. Again, family orientated, and again, the sorts of areas of disputes that really generate incredibly white-hot emotional responses to the issues. Coming down from that, there's generally civil, house conveyances. Criminal is fairly low down, quite frankly. It's family law is 20% of all the complaints we get. Wills and probate is 13%. Once you get down to general civil matters, it's less than 10%. And criminal law is down around 4 to 5%. So that's just a rough look at it. The other side of looking at it is what particular behaviours do people most complain about. And quite frankly, number one, when it's boiled down to it, is communication, either lack of communication or poor communication or rude communication or just inexact communication. So it's a huge thing we will probably come back to. Next after that would be what are essentially claims of negligence, not terribly serious matters of negligence, but that's essentially what they're saying. One way or another, they say that my lawyer didn't know what he or she was doing, and sometimes that may be right, and quite often it's not. But we very quickly bat them away, say, well, look, we're not the people to deal with that. Law cover is. So we're very glad that law cover exists and does such a good job. But the other one that's up there the same as negligence is
let me guess, is it? Yeah, it's got to be bills, doesn't it? Yeah.
Perceived overcharging and actual overcharging, It's huge. Well, when I say it's huge, it's on a level with all claims of negligence that come into our office. So it gives you an idea of the prevalence of it.
John, how often are complaints made by the opposing client compared to complaints from a solicitor's own client?
More often than I ever expected before I came into this role, because I'd never been involved in legal regulation before taking up my appointment some 7 or 8 years ago. So it was quite a surprise to me how many do. But again, they're mainly confined to the areas of family law, quite frankly. It's very sad that people are looking for someone else to blame for what they perceive to be an outcome other than what they are absolutely convinced was due and owing to them in all sorts of ways, not just financial, but child rearing ways and emotional ways. So, so the area of complainants, either who make up our existing or former clients or opposing clients, makes up over 66% of all complaints that come in the door. A small percentage comes from judiciary or the bench, magistrates, and there's also a small amount that comes from, shall we say, friends of or associates of, a party who they perceive was badly dealt with by a lawyer who should have done better.
Your last annual report highlighted the disparity between the documented research showing a high incidence of sexual harassment within the legal profession, but yet quite low numbers of formal complaints received. I was just interested, is that disparity still as great today as when your last annual report came out? What are the trends in that area?
Unfortunately, it still is exactly the same. it's going to take a long while to turn this huge cultural problem, which I believe the legal profession we have, and I own it as well. I've been a lawyer and in the legal game for over 40 years and plus now. We've all got to own it, and especially those of us who've been in it a lot more. Quite frankly, we haven't taken it seriously enough and dealt with it properly. And I'm hopeful that there are winds of change coming in that may affect that change. But formal complaints, people are quite understandably, when you look at the nature of what a legal career is all about and how it is almost invariably the less experienced and far more junior lawyer or non-lawyer in a legal practice, so secretaries, clerks, etc. They're the ones predominantly are the targets of this dreadful behaviour, and it is unlawful behaviour and has been since 1983 in every workplace in Australia. But so we've got a real problem that we as the profession who pride ourselves on being the upholders of the rule of law, and I know that phrase has had a few bandied experiences recently, but
yes.
I'm a great believer in what I believe is the true version of it, and it doesn't involve other things more recently. But we've got a real problem when we can demonstrably be shown to be not actually following that obligation imposed on all workplaces right across Australia since 1983, when the Federal Sex Discrimination Act came into play. I regard it as a really serious issue. I'm trying to do lots of things about it. One of the things I am doing about it is providing better avenues for people to make informal and confidential complaints with a view to at least getting a data map on where it's happening so we can better target our preventative and educational efforts, but also so that we can start to build up a level of trust and confidence with those people who have been targeted by it, so that in due course they may feel confident enough to go on the record, because they all realise that if they're taking on a senior lawyer, that lawyer is invariably either got the means himself, and it's almost invariably a he, or have got mates from law school days who will do it at mates' rates, and they're going to be cross-examined by a senior counsel or a QC in a court of law or a tribunal. And that's enough to turn any young lawyer's knees pretty weak, and I understand that. And I'm well aware of the danger and the potential that such a person could actually be even more traumatised by the experience in trying to follow through such a complaint than the original behaviour. So we've got to be very careful about it and very supportive. But my belief, my attitude and approach to it is we've got to address both sides of the problem. Firstly, give supportive and confidential avenues of reporting it and complaining about it. On the other side, of letting the continuing perpetrators know that their time of impunity is coming to an end, and people like me are going to be coming for them, because it's got to be zero tolerance from here on. I can't strike people off. I've got to take an application to the tribunal, and then if I'm successful there, invariably to the Supreme Court. But I'll do it. And, yeah, it is serious, and we've got to do a whole lot better. But I am pleased. I think it's fair to say on this topic, Julian, that one of the most decisive things that I've seen happen in the profession's response to this issue has been the realisation that this is a really serious problem subsequent to the reporting of the situation in the High Court of Australia and the former Justice Dyson Hayden, and that whole situation and the wonderful statement made by our current Chief Justice and the exemplary way in which she dealt with it. And it is a great exemplar to all leaders within the legal profession as to how it should be dealt with: supportive, confidential, call a spade, and don't beat around the bush.
Thanks for your comments on that, John. This next question is definitely pertinent to sexual harassment complaints, but I wanted to address it more generally. What proportion of the complaints you received are referred on to professional associations for handling?
Oh, well, on sexual assault, very few, but some. It depends on the circumstances of the respondent lawyer who's been complained about. But in the overall total, less than 20% of all complaints we receive are referred on to the professional bodies. we tend to refer a greater proportion of those complaints we received against barristers to the Bar Association and the Bar Council. And that is because, in large part, the barristers are so jealously protective of their reputation that my surmising of it is that they will take at least as hard line a response as that I or my staff may take. In relation to the matters against solicitors, we refer to the Law Society, everything to do with trust accounts. And that is, they're some of the most serious matters, but they have the gun trust account inspectors. There's no point in an agency like mine trying to reinvent that expertise in the wheel. So that is a large part of the matters that we refer to the Law Society, albeit some others as well. But of course, if I do refer a matter to either of the professional bodies and they perceive a conflict of interest, and that may be because of a person in the deciding conduct committee, whether it be in the Bar Council or the Law Society Council, may have a conflict, or even be a person themselves who's been complained about. It is, of course, inappropriate for them, yes. And they send it back and we take over it and see it through to the end. But I believe that it's good to have the professional bodies involved in a meaningful way in the regulation of the profession, because it means they bring a better acceptance by the profession to the whole operation of it, whereas it's far easier just to say, that Commissar McKenzie and his stormtroops. It's important to know, even if they don't believe, that I actually strongly believe in the legal profession and what a great role it does play, an even better role it could play in society. It's important for them to know that they're actually got skin in the game, and I think that that's really important.
You wrote in the most recent annual report that complaints are getting a lot more complex. Well, why is that?
Too easy to send reams and reams and reams of information digitally, quite frankly, is the first and obvious answer to that, is that now that people have a capacity, as recently as last year, to lodge complaints online via our website, people no longer send us targeted documentary evidence that they think they have for whatever's gone wrong, and say, well, here's the equivalent of 5 ring pull folders of documents. You'll find what I'm talking about somewhere in there. Well, sorry, we don't have that much resources. We need to go back and dig and get a lot more specific than that. But that's one of the reasons, is that the absolute avalanche of data that sometimes we're flooded with. The other things to say is that the law is, as time goes on, becoming more and more specialised. And there are areas of law that we have some very good, wonderfully talented lawyers working as legal investigators in my staff. We're not many, but they are good. But they may not necessarily be across the latest developments in intellectual property, just to name one field that is advancing at a very fast rate. So sometimes we need to get assistance on that, on the technical parts of that, on what is the most appropriate, efficient behaviour and performance by lawyers. So I think it's a combination of that, but predominantly it's because people just say, well, here's everything I ever got on this to do with this so-and-so, you work it out. And when we say, well, we can't work it out, and some unkind epithets come back.
Well, John, look, I've got to say, I'm enjoying speaking to you now, but I could understand it if the average practitioner maybe wasn't that keen to get involved in a conversation with you, or at least your office. So how could you say, from having looked over so many complaints, what are the best things that a solicitor can do, or any legal practitioner, if they hear an initial complaint, to sort of constructively regain a client's confidence?
Look, a couple of things. First of all is this. Having worked as a criminal defence specialist advocate for many years before I took this posting, I know from my own personal experience how emotionally upsetting it can be when you receive complaints from people who you think you've absolutely gone way beyond the usual call of duty for. And when you're a criminal defence lawyer, you've got a lot of ex-clients with a lot of time on their hands. Let's just put it that way. So, I know what it's like. And what I'll say to everyone is that when you first get notification of a complaint, it's understandable and okay to be upset. Do not reply when you are still upset, because that is the number one first trap for new players in this field, and that is that they fire off an email to me or my investigating staff, and in the contents of that email, sometimes, rarely, sometimes they come close to it and I give them the benefit of the doubt, but sometimes they are so offensive to my role and my staff that I seriously have to consider initiating a new complaint for them being so obnoxious to the legal regulator, with which they have professional ethical obligations to comply with. So don't make that mistake. Put it in the top drawer at least for a day. The other thing I would say to people is that get advice before you make a response, unless you think you can easily assist it by saying, look, there's been a misunderstanding of what the situation is here. This is what the case is really about, or this is what happened from the other opposing side, or this is the client's instructions that led us to this point. Be direct. Don't be argumentative in your response, because it makes our work at the Office of Legal Services Commissioner much easier if we can pass on in whole an initial response from a lawyer saying, well, we've received this response, have a look at it, we think it deals with all the issues that you've raised, but we'd like to know from you. So don't have in it, this person is a crazy, raving lunatic, because even if we excise that part of it, it usually comes through in the rest of the expression of the response. Be loyally, be professional, and get someone, especially if you're young and new at it, with a whole lot more experience, to cast their eye over your proposed written response before you press send. That's the best advice that I can give to you. The other advice is on perhaps the other end of that spectrum is don't put it into your basement vault and pretend that it will just go away, because unfortunately I'm not allowed to go away. I have to follow through. And if you don't reply, then this starts to escalate things and it gets more serious from there. So be reasonable, but don't reply straight off if you're upset. But don't say, oh, well, that can wait till next year if you're sitting here in the middle of June. So, take a sensible path about it, and just realise this is that, and I'll say this, and I think it's great for lawyers to hear this, is that out of the 2,500 average number of complaints we receive a year, close to 50% of them are closed and dismissed very quickly, either because they've got the wrong idea, they're without substance, this simply needed to be communicated and explained better, or they're complaining about the wrong person. So, don't assume because you've got a complaint made against you that, time's up. Yeah,
so cooling off period's a good thing, but don't let it go on ice. I'm sure Law Cover's keen to hear from insured practitioners at the earliest possible stage as well. But John, is it best to try and resolve the complaint directly with your client at the earliest possible stage?
Quite often I think so, yes. But look, you need to be making a judgment, about the seriousness of the complaint that you've been made aware of. If it is of the nature that it is really making allegations of almost borderline criminality against you, I don't think it's really worthwhile to be trying to deal with it directly with the client. You're best to go through the formal complaint process, with my office being an investigative middle person, if you like, to at least mediate the communications. However, if it's a relatively small matter and it's not a serious sort of intentional dishonesty or self-serving type of complaint, then yes, good idea to try and deal with it with the client. And this particularly applies to the allegations of overcharging. Don't get up on a high horse. Explain to people, but also explain to them, but yes, you do have the opportunity to make a complaint, but there are time requirements about that. But this will bring in the area that we do need to talk about, and that is that particularly solicitors really need to be mindful of your ongoing and serious obligations about cost disclosure, because under the legal profession uniform law, you've got a very serious obligation to keep your client in a situation where they can be said to be giving you informed consent to continue in the matter. And so we need to deal with that.
And as you're saying, yeah, that's clearly one of the major areas of complaints made. John, if it does come to a complaint being made to you, how does the process work from there?
First of all, an assessment's made on the face of the complaint, and you've got to remember we're only getting the complainant side of the story at that stage. Were this to be accepted or be able to be proved through evidence, is it of a seriousness that is going to have to be treated as a serious disciplinary allegation with a potential for proceedings such as heading towards actions for unsatisfactory professional conduct, or the big one that no one wants to go down on, professional misconduct? Or if, on the other hand, it's in the second category of complaints that we use, and that is of consumer-level complaints, delays, communication, overcharging, then we will try and act as, in a way, a shuttle diplomacy between the lawyer and the complainant, so that once we are sure that we understand what the complaint is really about from the complainant, we'll approach the lawyer, usually by writing first so that they are not caught cold by a phone call. But the idea is to say, well, look, let's try and cut to the chase of this, because I have instructed my staff to take very seriously the obligation we have in consumer level matters to try and resolve them as speedily and as informally as possible. But that doesn't mean that we cut corners. It just means that we are actively trying to find a spot, and usually some compromise from both, or at least one party is going to be required for that, to agree to some sort of an outcome that people can live with. Now, lawyers should understand that sort of attitude, because essentially a hell of a lot of civil litigation and areas around that and considerations around that really come down to exactly the same principle, is that you're never going to get everything you want, but let's see if we can get something that you can live with. And so my staff will explain to, as much as best we can, to the complainant whether they are a little bit misguided in what they thought that they could properly demand or expect of the lawyer. And at the same time, in communications with the lawyer, they will try their best to explain, well, this client says that all the last cost update they got was $5,000 less than what you've ended up charging them. How do you explain that? And so it's a matter of trying to lead people to a middle path on those consumer matters. On the disciplinary matters, we've got to take a proper investigative approach and say, well, we're looking for evidence. If we find serious evidence, we're off to court.
How long does it usually take, say, for the consumer matters to be finalised?
We aim, our goal is to try and have over 55% of all consumer complaints completely done and dusted within 6 months of receipt. We do reasonably well on that, but in COVID times, that time has blown out, because everything takes longer with COVID. And we also need to be more, I think, quite rightly, empathetic with lawyers, especially in small practices, that they've got so many other difficult demands on them with the COVID times and keeping a practice going. We do allow longer response times than perhaps we ordinarily would. In relation to disciplinary matters, if it's going to get as far as me taking it to the tribunal and then on to the Supreme Court, we're usually looking at 2 to 3 years.
It's interesting you mentioned COVID. Has the pandemic changed the sort of mix of complaints that you've been receiving?
To an initial extent, yes, but I think it's already of such notice and concern to me that I do want to take this opportunity to mention it. And it's around the whole quite productive and positive changes to the legal requirements about the witnessing of formal legal documents, especially family estate type documents, whether they be wills or codicils or powers of attorney, etc., but also some other serious documents like affidavits and so on. all the practitioners, the solicitors that deal in that space, they'll be aware that the regulation, the Electronic Transactions Amendment regulation, it's back in force and has been, during this second lockdown, reinstituted from last year. It's fairly uniform right around Australia. Can I suggest to people, if you want to just see how seriously the courts will take the proper, and I mean proper, almost to the minute detail, obligation of doing what's involved, because I think the courts are coming to this question from the point of view, well, we're only really happy with this electronic witnessing because of COVID times. They obviously would much prefer us to be still doing it in person, but if that's the way it's got to be, then we're going to hold you to every little detail that is required. And there's a Supreme Court judgment from earlier this year in Queensland, from the Queensland Supreme Court. The name of the case is Sheehan, Sheehan, and it's worth anyone who wants to sort of really motivate themselves to make sure they do the remote electronic witnessing right. Go and have a quick read of it, but I'll give you the takeout of it. And the takeout of it is the will that was in question in this case in the end was waved through, but you will appreciate the huge hurdles that the lawyers had to satisfy in order for it to be waved through, because there was one or two very small and on the overall view of it, very minor deficiencies in following the strict procedure. But I think if anyone wants to just appreciate what I would call the heightened attention to detail needed, go and have a look at the Sheehan case of earlier this year. It's reported in Queensland Supreme Court 89 of this year's reports.
Thanks very much, John. Now, you've already alluded to some of the key things in terms of minimising the risk or the likelihood of a complaint being made, and the ongoing disclosures in relation to costs are obviously very important. What other things should practitioners keep right at the front of mind in terms of trying to minimise those risks of complaint?
Get organised. That's the best general advice I can give to you. I mean, I'm not going to pretend that I was, 100% organised all through my practising career.
Come on, John, you're the commissioner. You can pretend now. It's part of this is one of the benefits of office.
Look, you can take that view, but quite frankly, this is the real world.
Yeah.
But get organised, because it'll help you. In the end, it will save you time and angst. That's my serious advice to people. And that goes from having systems in place in your practice to keep track of matters, diary stuff that all legal practitioners and the legal secretaries who need to can have access to, so that you're not double booked. Keep track of when things are due to be done through orders that you've got an obligation to do, or any undertakings that you give. Importantly, when it comes to things such as conflicts of interest, just have it done. It's got to be done every time, and so it can be ticked off. Don't make the mistake of saying, "Oh no, I'm sure I don't have a conflict." Check. Those are the sorts of things to start with, and remember that although law should not be done in a rush, you're living in the real world, and people are more and more used to having, shall we say, their wants, desires and demands satisfied a bit earlier than perhaps 10, 20 years ago. So timeliness is really important. So think twice about overloading yourself with matters such that you're not going to get to any new cases you take on until well down the track, because that may be a recipe for long-term demise of your practice. Because if the word gets around, McKenzie and his mob take forever and go somewhere else, and you might pay an extra $1, but you'll be happier. So bear that in mind. I think the other thing is communications. It's one thing I know in my legal education never was actually really dealt with, but it is such an important skill for lawyers to have. And you don't have to be, you might not ever go anywhere near a courtroom, but you've got to be a more than a half decent communicator with your clients if you want to be able to take a practice forward in this day and age. And that's because society's changed. Society no longer is prepared to say, "Oh, I've put it in the hands of my lawyer. He'll make sure he does the right thing. He'll let me know when it's all done." Well, no. That's just so old thinking that even someone like me is a bit embarrassed to say it. So can I say, one of the things that really sticks in people's gullets is that when, for one reason or another, it may not be because they're particularly dissatisfied with the current lawyer, but that they have cause to need to change lawyers mid-matter, and they go through the proper process and ask for it to be transferred to the new lawyers. People really get upset when that is given such a low priority. They think, well, stuff you, I'm going to complain to the commissioner and make this this lawyer's life as hellish as possible. So bear in mind, don't think that just because you may think you've lost a client, you could lose a hell of a lot more clients through the bad word of mouth that they will go on about if you really delay in the proper transfer of matters when you've got obviously you need the authority, the written authority and all the rest of it, and if needs be a security for your costs. But attend to it quickly, because think of it as insurance. You may have lost this client. You don't want to lose every person, every associate or everyone who reads this person's social media feed, because that's what happens. It's quite amazing the change in the word of mouth now. It is so instantaneous. People need to be really aware of that. So timeliness is a good one. Communication, just to come back to that, I didn't deal with it properly, and that is to say you need to be tailoring your communications to your client. You need to become a good judge of person. What type of client is it? Is it a complete newbie or is it an experienced frequent traveller? If it's a complete newbie, maybe you need to err on the side of direct, simple explanation and ask a few questions at the end of it to make sure they've actually understood correctly what you've said the case is about and what you propose to do. If they're a frequent flyer and they have come back to you because they like the work you do. So horses for courses. And that fits with the principle-based approach in the legal profession uniform law, and that is your obligation is to put each particular client into a position whereby not only the beginning of a matter, placing it in your hands, but all the way through the ongoing prosecution in the more general sense of their matter, is they need to be in a position of informed consent, of agreeing not only to what you're proposing to do, but the estimated, and it is only an estimate, but the estimated cost of doing that. And that's why an automatic system whereby you can really easily update your cost estimate on a matter that, for whatever reason, from something the other party's done or something your client has asked and has brought up something that you weren't aware of when you first got instructions, have a real simple, easy way, usually by email these days, because a lot of clients, especially in COVID life, I don't know what it will return to afterwards. The massive predominance of all communications is done electronically these days with clients. Have an email template set up so you simply put in the file number, the matter number, and say due to, and fill in a couple of words, actions by the other side. They've taken a complicated discovery path, or they're putting us to the test on this procedural point. We need to renew what we're saying is our new estimate of cost expenses, because what I tell you is the main generator of complaints when it's cost related is what I call the nasty surprise of the final invoice that is out of kick with what that client was expecting. So take your client with you on the journey. Prepare them for it. If they say, well, no, this is all getting too expensive, well, you need to put to them, well, the alternative is that you withdraw from the matter now, perhaps, and live with what it was that you wanted to achieve, or allow the other party to achieve what it is that they're trying to. So you need to be careful. You need to be delicate about it. I'm not to say that you just tell them take it or leave it, but they need to be explained so that they have at least an estimate of what they can reasonably expect, because I really strongly believe that it's that effect of when they open that final cost invoice and see the figure, and it's not good news, and perhaps the case didn't go too badly but didn't get everything that they wanted, which is ordinary part of life. they're going to say, well, this is outrageous. He didn't update me on this rising costs. He should have let me know. I'm not going to pay it. And that's where it all comes from.
Well, thank you for updating us, John. And hopefully as a result of this conversation, there'll be a little lighter load on the Office of the Legal Services Commissioner. And I'm sure that all the practitioners who don't find themselves having to deal with those processes will be happy for that as well. Thank you so much for joining us, John McKenzie.
Thank you very much for having me, Julian. And I regard my ultimate goal in this job is to do myself out of the job. I really believe that. I'd love to try and minimise the complaints. There will always be complaints, though, because unfortunately a very, very small number of lawyers do the wrong thing. But in the greater space of things, I'm a great supporter and believer of the legal profession. I think we do a wonderful job on the whole. We can improve in some areas. We've mentioned some of them today, and I just want to encourage everyone, especially the newer members of our profession, approach it as a wonderful voyage of discovery, a career of legal practice, and I encourage you to do your very best.
Thanks very much, John. That's John McKenzie, the Legal Services Commissioner of New South Wales.
Thanks for listening to Risk on Air by Law Cover. Join us for the next episode and subscribe to stay up to date.